You are on bond in this court for a terroristic threat. What is the only thing that I asked you, or we asked you not to do? What did you do? Guess what happens now? Guess. No guesses? Right. You're clairvoyant. He goes with you. He's on bond for the terroristic threat and picked up a felony theft. No, sir. You will stay with me now. Oh, Mr. Spiller, you're back yet again. Both of you gentlemen are charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay?
Officers were investigating and controlled by for a possible stolen skid steer from a known felony theft suspect who had an active felony theft warrant involving the sale of a stolen skid steer. Officers...
Okay, stolen what?
Skid steer.
Skid steer.
Your Honor, it appears to be like a tractor of some sort, kind of like a small bulldozer. It's just what it appears based on images.
What's the value of that? It's got to be felonious for sure.
I'm not sure about the value in this present case, but they range from $5,000 to $50,000.
Right. Okay.
So officers observed the suspect vehicle follow the officer's unmarked vehicle for several miles, making the same turns and traveling the same routes. Officers conducted a stop for the expired registration and no return of valid proof of financial liability. Occupants were Defendant Spiller, Defendant McGuire, and known felony theft suspect Defendant O'Neill. Officers observed in plain view several clear baggies containing a green leafy substance. Officers knew from training and experience the substance was marijuana, and it was within the center console in the immediate reach of both Defendant Spiller and Defendant McGuire. The weight was 1.01 ounces. Defendants exited the vehicle and the officers located a pistol in the front center or the front passenger door area where Defendant McGuire was sitting, a clear baggie with a green leafy substance that officers knew to be marijuana. And on Defendant McGuire's person, a key to the skid steer in the back seat area where Defendant O'Neill was sitting. Defendant McGuire claimed ownership of the pistol.
So no gun case, I guess? Did you guys confiscate the weapon? And so where was the marijuana again?
Marijuana, I think, was in the center console.
So how do we get Spiller into this thing?
So it just says officer observed in plain view several clear baggies, and it was within the reach of both Defendant Spiller and Defendant McGuire.
Did anyone claim ownership of the weed?
It doesn't say that they did. I know that like I said, Defendant McGuire claimed ownership of the pistol, but I don't believe there was any ownership claim for the weed.
Who's driving the car? And I guess in that as well, who owned the car? I'm looking for the office report in each of these other agencies, and No problem.
The driver of the vehicle was defendant Spiller. I'm looking for the owner. And I believe the owner of the vehicle was Spiller as well.
So the weed was just, you said, in the center console, right?
The marijuana, the offense report states that the marijuana was in plain view of the officer and that it was in reach of both defendants.
I mean, I'm down with it on Spiller, but I'm not going to impute it to McGuire, you know? I mean, if you can show me somehow that he has care, custody, control somehow, then I'll find PC on McGuire. But otherwise, I'm going to find no probable cause. But I am going to find probable cause on Spiller.
I'm just looking through the offense report from Pasadena.
And I mean, we can, because we have a lot of people waiting. Let's do this. I'll give you a bit of time. Mr. McGuire, take a seat from the jury box for now. Mr. Spiller, I'm going to find that there's probable cause to go forward with the case. Do you have a Texas driver license? Run his license, please, as well. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Mr. Spiller, I'm sending you for a drug test right now as well, and I want to know what, if anything, is in your system. If it's just weed, I'm going to test you again in 35 to 40 days, and if I find that you continue to smoke weed, I'm going to put you in jail. Do you understand?
Yes, sir.
This is now your 5th case within the last your 4th case within the last year and a half. Things are not going well. What do you do with your life?
Work.
Doing what?
Construction.
Is it a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
I'm sending you for a drug test. You must come right back. You understand?
Yes, sir.
When you come back, we'll talk about your lawyer situation. Don't jet. Otherwise, I'll revoke your bond.
Yes, sir.
And I'm telling you now, I'm going to make it sky high. Do you understand?
Yes, sir.
Okay. I will have you sign a resale with Victoria, and then we'll send you down here momentarily. That way. Shh. Mr. Roy, how's jail? Really? You really don't like it, or you just kind of don't like it?
It's over with for me. I've been through it. I don't know.
You know, why do we have jails? Tell me. Okay, why else?
Bad actors and keep people safe.
Is that you?
Which one?
All of the above.
No, sir.
Really? Tell me why not?
Okay, for the last 3 years I've been in school. I graduated from University of Phoenix, business management. Since I've been on probation, I've worked 12 hours a day, and I've just been clean. It's just unfortunate this situation happened.
Since 1994, Mr. Roy, 1, 2, 3, 4, 5, 6, 7, 8. Nine, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21 crimes And in 2021, you pick up an injury to a child under 15 with serious bodily injury. You get on felony probation in 21. Now you've picked up a Class A criminal mischief, which is all about self-control. I don't even know what happened in this case. So we're going to find out real quick. But let me ask you again. Why do we have jails? Is that you? Should we go through the criminal history again?
Okay, when you say 94, I'm 48 years old now.
Shh.
94, if you go back to 2006, from 2006 all the way to 2021, I haven't had no major cases. Y'all haven't seen me in y'all jails from 2006.
Were you in prison?
In 2006, I got out in 2006. And from 2006.
That's why you didn't get in trouble.
No, 2006 to 2021, I haven't gave y'all no problems. I was on the road to change. Unfortunately, in 21, this incident happened. They gave me felony probation because they couldn't really prove it, and I could get this wipe off my case. Withdrew the deferred probation. Now, 3 years later, after that, I get this, which we don't have the real information on why this case came about.
Let's do probable cause.
But I did.
But
I wanted to let them know about my university.
one of the main other reasons that we have jails are for you to learn.
Okay. Yes.
For you to understand that everybody in custody now, no self-control. They wig out, do whatever they want to do, injure whoever they want to injure, kill whoever they want to kill without thinking of consequence. What happened here?
922 officer was dispatched to 8319 Cardamom Lane in Harris County, Texas. The complaining witness, who is the defendant's sister, told the officers that the defendant accused her of stealing his wallet. The defendant got aggressive and grabbed a gallon bottle of soap and attempted to hit her son with it. The complaining witness began to get into her vehicle with her son to leave while the defendant was still attempting to hit the child. When the complaining witness returned from the house, there was a hole in the wall, a PlayStation 5 was broken on the floor, and her son's school-issued tablet was also broken. Later, the defendant received a call from Walgreens that he had left his wallet at the store earlier that day. Total damages approximately $2,750.
So you think that allegedly here, because mom takes a wallet, the son who is in school uses the computer to learn, has to allegedly suffer.
That's not how it happened, sir.
That's why we have trials, Mr. Roy. But I'm going to tell you now, if you think that I'm about to give you a PR bond, you got me bent sideways, because there's no way that me here with all your priors, being on felony probation for injury to a child, are now allegedly trying to injure, yet please tell me it's not the same complaining witness.
That's what I'm trying to figure out right now, Judge. Because in the previous case, it was his nephew. So I'm trying to figure out if it's the same child.
It's not.
Shame.
And I was allegedly too on the probation case. So this is why I'm here, because that was alleged too, because they put me at the same address.
You pled guilty to it.
If you're not guilty, then don't plead guilty, Mr. Roy. That's just the bottom line. Don't come in here.
I didn't have a choice.
You didn't have what?
I didn't have a choice.
You always have a choice. There's always a choice, Mr. Roy. Don't come in here and try to piss on my leg and tell me it's raining. I think that you are a complete and utter danger to the community. Really. And you what? Lori, I'm sorry, but there are some people who really merit either a PR bond, a lower bond. At times, I really think that they deserve even a higher bond. His bond is $2,500 right now. I think that is completely insufficient, and I'm raising your bond way higher, Mr. Roy. I think you're a complete and utter danger to the public, and I'm going to do everything in my power to protect every single person, including nephews. Thank you. And I'll find probable cause.